Well, a small-town mechanic in Ontario remains on the hook for damages after a drunk, unlicensed teen, along with a friend, stole a car from his unlocked garage and crashed it. Now, one of the teens suffered a permanent brain injury and sued the garage. The court determined that this garage was the most liable for the crash, and last week, Ontario's top court upheld that decision. Sivan Tumarkin is a personal injury lawyer, and he joins me now to discuss this case further. Good to see you this morning, sir.
Morning, Jeff.
All right, let's break this ruling down. Now, why did not one but two courts find the garage in this case the most liable? I think we need to point out that the car was left unlocked with the keys in the ashtray, but here we have a 16-year-old who was given alcohol by his mother earlier on, yet it's the garage the most responsible?
That's right. So first of all, you've had a jury decision that said that the garage is 37% liable, responsible for the accident. And then you have the jury coming back also and saying that the mother who provided the 24-case beer is 30% liable. And then you had them say that the teenager that was driving the vehicle, the 16-year-old, the court called him CC to protect his identity, that he was 20% liable. And then the final, the victim, the 15-year-old, was 10%. And so this was a jury decision, and the decision was upheld by the Court of Appeal of Ontario.
Right. Now, how does the court not find the driver, the perpetrator here, the most responsible? Or maybe even the mother, 1 and 1A, who gave this underage teen alcohol? Why is it the garage? And is this just the continuing death of personal responsibility?
That's a very good point, and there's been a public outcry as a result of this decision. And it's stemming primarily from this nonsensical view that, you have to hold other people responsible for the acts that you commit. Now, if you listen to the public and you gauge their reactions, you're not getting a lot of people who say that there should be no responsibility on the garage or the mother or anyone else. What they're saying is that the garage was saddled with the lion's share of responsibility. And that's what's insulting the majority of the public. But keep in mind, this was a jury decision. So the trial judge charged the jury. They provided the jury. She provided the jury with instructions. She stated that the garage owed a duty of care, which is the legal principle that underlines the finding of negligence here against the garage. And then the jury came back with its decision. Now, keep in mind, the decision itself, it's kind of strange to think about the percentages. 37%, 23%, sorry, I said 23%. It almost
it's not like it's 25, 40 there.
It almost seems as though the jury was negotiating amongst themselves and came back with this unanimous decision of the split.
Okay, I got a minute here. Do you believe that this ruling establishes a bit of a dangerous precedent in this country?
I do. And the Court of Appeal specifically noted in one of its later paragraphs in the judgment that this has limited scope, that it would not apply to an individual who leaves their keys in their own car on a driveway. I'm not sure that they've limited the scope significantly enough, meaning imagine a February morning, a cold morning, you're going outside, you're leaving your keys in your car, you have your car turned on so you can warm up the car. We're warned about this by the police a lot, not to do that because of the risk of theft.
Right.
Imagine somebody comes in, steals the vehicle, causes an accident. Now you as the homeowner, you're going to be responsible. Now you can extrapolate that. What happens if you leave a bat on your front yard? Someone comes and picks it up. And then there's a fight.
Case that's going to have ramifications for sure. Sivan Tumarkin, great to see you this morning. Thanks for coming in.